Hey guys, welcome to my legal classes. This is Ganesh Pujari and today I am going to take you guys through one of the important aspects from Hindu Marriage Act, that is void and voidable marriages, which are discussed under section number 11 and 12 of Hindu Marriage Act 1955. Guys, I was discussing about the important matrimonial remedies available under Hindu Marriage Act, and we have already seen the videos on section number 9, restitution of conjugal rights, and the section number 10, which is discussing about the judicial separation. Now, what if a marriage becomes void or voidable under Hindu Marriage Act, or when a marriage becomes void or voidable under Hindu Marriage Act is discussed under section number 11 and 12. First thing first, let's try and understand when a marriage becomes void under Hindu Marriage Act 1955, which is being discussed under section number 11. Guys, there are three important reasons when a Hindu marriage becomes void marriage. They are discussed under section number 5.1, section number 5.4 and section number 5.5. Section number 5 basically deals with the essentials of Hindu marriages or the requirement for Hindu marriages. Section number 5.1 says if there is bigamy, the marriage is void. There itself we have got the first reason, when there is a bigamy, the marriage is void. And the fourth and fifth are dealing with marriage between the prohibited degree relationship or Sapinda relationship. If there is a marriage between prohibited degree relationship or Sapinda relationship, the marriage is void. In all these three cases, please remember that the marriage is void ab initio. That means in the eyes of law, there is no such marriages available. So that's very important to remember, and these marriages are completely void. But remember, the children born out of these marriages are legitimate children. They get right on the property of both husband as well as wife of such void marriages. To read out the section, any marriage solemnized after the commencement of this act shall be null and void. Remember the words null and void, and may, on a petition presented by either party thereto against the other party, be so declared by a decree of nullity if it contravenes any one of the conditions specified in clauses section number 5.1, section number 5.4 and section number 5.5, which are bigamy, marriage between prohibited relationship and the marriage between Sapinda relationship. That's all about section number 11. Let us try understand the voidable marriages under section number 12. There are four grounds for which the court can give a decree of voidable marriages. They are impotence, number 2, unsoundness of mind, number 3, marriage happened with force or fraud, number 4, wife being pregnant before the marriage itself. For these four reasons, court can pass the decree of voidable marriages. What is impotence? Impotence is not inability to have the child, but inability to have sexual relationship. In that case, court can give a decree to the aggrieved party for the voidable marriage. In the case of unsoundness of mind, which is discussed under section number 5.2, in that case the marriage can become voidable marriage. If a marriage happened due to force or fraud, in such cases marriage become voidable marriage. And in the case of wife being pregnant before the marriage, which is discussed under the case law Mahendra versus Sushila Bai, where Sushila Bai delivered a child within the 171 days of her marriage, court held that this was not with the relationship of Mahendra, but she had a relationship before the marriage itself, and that caused the child. In that case, it can become a voidable marriage. These four reasons, remember: impotence, unsoundness of mind, marriage happened due to force or fraud, or wife being pregnant before the marriage can become the reasons for voidable marriage. Now I am quickly taking you guys through the differences between void and voidable marriages. The first one, void marriages are void ab initio. They are not existing in the eyes of law. That's very important. Whereas voidable marriages are existing in the eyes of law only after the application from the aggrieved party. Court will take the decision on the same. In the first case, void marriage, court simply passes decree of nullity, whereas in the voidable marriage, court will see all the required condition and only on satisfaction gives the decree of nullity. Third one, in the case of void marriages, parties can remarry immediately without waiting for court's order, whereas in voidable marriage, parties have to wait for the decree of the court, and only after the decree they can marry again. Fourth one, in the case of void marriage, wife cannot claim maintenance under section number 125 of Criminal Procedure Code, whereas in the voidable marriage, wife can always apply for maintenance under section number 125 of Criminal Procedure Code. Void marriages are void ab initio, whereas voidable marriages are valid till challenged and got approval by the court. The next difference is parties are criminally liable in the case of void marriages, whereas voidable marriages mostly they are not criminally punishable. The last one, the third person also can raise if it is a void marriage, whereas voidable marriage only the aggrieved party can put a case. These are the major differences between void and voidable marriages. You can take the screenshot for the purpose of reading, and with that I am concluding this session. Thank you so much for watching me. All the very best for your exams. Please subscribe, share, comment and like my videos. Thank you and all the very best.